My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar, and it's my pleasure to welcome everyone to our presentation on the new Partition Act today. Before we begin the program, I want to let everybody know about our upcoming programs. January 15th, tomorrow, we are going to do a program with the former president of the state bar as our speaker, Heather Rosing. Heather's topic is cutting edge ethics and risk management for real estate lawyers, not necessarily your typical ethics program. She's going to talk about ethical management of artificial intelligence tools, lateral hiring risks and rewards, developments in conflict of interest standards, and recent developments in trust accounting, and also new legislation on lawyer advertising, among other subjects. February 26th, we're going to do our annual real property tax program. Chris O'Neill from Greenberg Torrig and one of his partners will be presenting that program. March 19th is our annual California Association of Realtors form update. Jana Gardner is joining us yet again to go over their new forms and updated forms and tell you what's new at the California Association of Realtors. Always a very good program to hear the latest from CAR. April 16th, Howard Fisher is going to do a program on 1031 exchanges. April 23rd, Larry Jacobson is going to do his annual review of the prior year's real estate cases. And May 21, we're doing a new topic. Steve Raucher is going to talk about landlord insurance coverage for habitability claims in landlord-tenant cases, which has become, I think, a significant issue for landlords, given the number of habitability claims that are raised in those matters. So that'll take us all the way through May. Two comments before we begin. The program material link is in the chat, so you can find the link in the chat. And secondly, we use the Q&A for questions, not the chat, so put your questions in the Q&A, please. And the speaker is going to monitor those for you as we go along. My pleasure to welcome Elijah Underwood as our speaker today. Elijah operates a law firm with a heavy specialty in partition law. That's today's subject. In addition to partnership disputes and more general real estate law, they have extensive experience handling partition trials and complex partition actions, including multiple property, multifamily, industrial, commercial, and multi-million-dollar property partition actions. His firm has handled in the neighborhood of 425 partition actions throughout the state of California. He lectures on partition actions for the California Association of Realtors and is a member of the Executive Committee for Real Property for the California Lawyers Association. He's a graduate of UC Hastings Law School and UC Santa Barbara, and we thank you for coming, and the floor is yours.
Great. Thank you so much for that warm introduction, Howard. So good afternoon, everybody. I'll start with my PowerPoint. We'll get it going here. So as Howard mentioned, I have a law firm, and basically all that we do is partitions. Obviously if there's related matters, so sometimes somebody will claim there's a life estate, or there'll be an issue with divisibility of property or certain things like that. We'll handle them as part of the partition, but basically the firm's sole focus is partitions. I think our running total is close to 500 partition matters handled to date. And so I'm very excited to present to the Beverly Hills Bar Association on the most recent Partition of Real Property Act. As mentioned, I've been an attorney since 2009. The firm is actually up to about closer to 20 members. And we have offices throughout California. I'm in LA, but we also have people in Sacramento and San Francisco and San Diego and Orange County, and we have offices there, and we're handling partitions throughout the state. So today I'm going to go through 10 key provisions of the partition law, some background on the act, partitions and probate, statutory provisions, title issues, some of the procedural stuff, basically give you guys a very nice overview of the act. Before we began, I was mentioning to Howard that I've given this presentation in a half an hour format. I've given it in a 2 hour format. So today I'm going to give it in an hour format, and happy to answer as many questions as possible. I'll try to break right at about the 50-minute mark to answer some of those questions. But all this is to say there's a lot more information that's out there that we could cover. I'm going to try to keep it pretty tight this afternoon. So as a little bit of background, the act is a uniform act. There's a conference that deals with uniform acts to try to implement uniformity across the states. And the background on the act was there was some issues, particularly in the American South, places like Mississippi, Kentucky, South Carolina, places like that. And there was these studies done by this gentleman named Thomas Mitchell, who's a law professor. He was at the University of Texas. Now he's at Boston University. And in his law review articles, beginning in about 2003, he surmised that there could have been, it's possible that there was this loss of property, particularly in African American communities in the American South, due to a lack of access to legal services, was his hypothesis. He wrote this article, a series of articles. These articles are what led to the promulgation of this Partition of Real Property Act, this Uniform Act that California adopted in 2022. Later, however, Mitchell kind of recognized, and actually he got a study from the Carnegie Foundation to do a study in North Carolina to see if his hypothesis could play out, if there was any records for it. And ultimately, what he concluded was that there was really no evidence for this hypothesis, either about a relative lack of access to legal services or a loss of land due to partitions. And so basically, he had this mistaken hypothesis, but nevertheless, we got this act out of it. And so that's will kind of play out as we go along. It is kind of an important historical point that Mitchell himself kind of recognized that he couldn't evidence his theory. And so how this plays out is we have this claim about this concern from, again, places like Mississippi and maybe Kentucky or Tennessee, and the act gets imported into California. And what we have in California is the 19 basically, for those of us who are veterans of the field, we have the act that was last reformulated in 1976, the 1976 revisions to the Partition of Real Property Act, which has basically it's 106 different unique and separate statutes that make up what we know as the partition law. And then in 2022, there's this drive to add uniformity. And so then the Partition of Real Property Act is added basically right on top of the pre-existing law from 1976. And that's relevant for those of you who have practiced in other states, or even just here's a rare thing, gone down to a law library. And if you go to a law library and you take a look at the statutes of California, you'll see the Civil Code and the Code of Civil Procedure and the Welfare and Institutions Code and the Health and Safety Code and the Probate Code and the Water Code and on and on and on. Whereas if you were to peruse, let's say the statutes of Oregon or Nevada, you basically just find like the Oregon uniform laws, and it might be, I don't know, 20 volumes or 30 volumes, something like that. Whereas California, it's almost like, several walls of books. And this is relevant because, in places like Georgia, maybe they're more like, for example, Nevada, where they have, a set of laws, but they're just not as extensive as the set of laws we have here in California, which probably says something. But what it, for our purposes, I think what's relevant is that this Partition of Real Property Act maybe is the only law that, Tennessee has on partitions or South Carolina has on partitions. And it kind of stands on its own because there wasn't maybe a set of laws addressing it. But now in California, it kind of exists among all these other laws, and it doesn't necessarily relate to them and interweave itself as well as it may in a place like, North Carolina. So that's kind of an important frame of reference here. And so for those of you who are just kind of attending, trying to get those CLE hours before the February compliance deadline, the March compliance deadline, partition it's just the procedure for segregating and terminating common interests in the same parcel of property. It's a remedy that's much favored in the law. And I think, but how most of us see this play out is, you're in your office and you have a client walk in and he says, I've got a brother, but my brothers, we're twins, but he's very different than me. I have one way of looking at the world, he has another way. But they've inherited mom and dad's house. And so when they inherited mom and dad's house, they have, because maybe they're twins, but they're very different people, they have very different ideas about what to do with that real estate. One of them wants to keep it, one of them wants to sell it. One thing's for sure is it's a bad idea for both of them to live there together. And so a fight breaks out and they, start disagreeing. Usually these fights go on for a number of years. And then one of the brothers or family members ends up in your office. And so what we have here is this tool, the Partition of Real Property Act, as a tool to deal with this dispute about this piece of real estate. And it's an act in three parts. There's an appraisal provision, there's a buyout provision, and there's a sale provision. And so, as what we're going to do today is we're going to go through the main provisions of the Partition of Real Property Act and look at some of the terms and see if we can't make sure that we have a really good understanding of each of the terms. So the act begins by saying that it applies to real property held in tenancy in common, where there is no agreement in a record binding all the co-tenants, which governs the partition of the property. And it applies to actions for partition filed on or after January 1st, 2023. So I think that to a lot of us, that probably seems pretty straightforward and pedantic. Probably not a lot to question there. Um, except what happens when there's multiple parties and only some of the property is held in tenancy in common, but others are held in joint tenancy. So, for example, you could have a situation where, let's say instead of two brothers, you have, let's say it's two brothers and their wives. And the deed to the children says, okay, to son and wife as joint tenants, and then to, son number two and his wife as joint tenants, right? And so maybe between the parties, between the couples, they hold it in tenancy in common, but between them, they're joint tenants, or maybe they're not, husband and wife, maybe they're boyfriend and girlfriend. You can imagine, a number of different permutations, and I've seen a few. But the question is, if the property is held in joint tenancy by some of them, does the Partition of Real Property Act apply? It says it applies to property held in tenancy in common, but we don't exactly have that. We have joint tenancy and tenancy in common. So because it's not an absolute, is the term satisfied? Is the provision satisfied such that the act would apply? It's not totally clear. What happens if you have three children? Let's say a son and a daughter, and they don't have spouses, but it's just given to them all as joint tenants. But then one of them decides for estate planning purposes that they're going to take their property and put it into their trust. And so they were all joint tenants, but now one of them has severed and they're a tenant in common versus the other two are still joint tenants. Does the Partition of Real Property Act apply? Does it apply if one of the joint tenants wants to partition vis-a-vis the other tenant in common? If the tenant in common wants to bring it against the other joint tenants, does the Partition of Real Property Act apply? It's not really clear how that situation should be addressed. But let's move on. Okay, so it says it applies in, cases in 2023. As we get into 2026, this is less of an issue, but in 2024, what happened if you had a a suit for partition, and then the complaint gets amended. It gets amended and it was filed in 2022 and it gets amended in 2024. Is that an action filed after January 1st, 2023? Does it pertain to the amendment? How do you address that? What happens if the suit started out as quiet title, basically one, brother seeking, let's say, an adverse possession claim against the other, and then later they add a partition claim. Well, the suit was filed before 2023, but the partition claim is new. How do you deal with that? That's not totally clear. So again, it says it applies to property held in tenancy in common. What's a life estate? If somebody asserts that they had a life estate, and let's even say they can evidence it, are they a tenant in common owner such that they have rights under the Partition over Property Act? If the tenant, or is the reverse true? If somebody says that, that this partition is broad, and somebody says, "Well, I have a life estate in addition to a tenancy in common claim," does that subject to the Partition over Property Act? Right? What if they claim to be a constructive trustee, something else entirely, right? So there was no specific agreement about tenancy in common. Are they a joint tenant? How does the court determine that, right? Um, and having litigated these questions, the answer is just yes. The answer is courts come down differently on them. But so even moving on, how is this right raised? Is it something that a party needs to bring in, the law of pleadings is that the pleadings define the outer materiality of relevance of the issues. So if somebody doesn't raise the Partition of a Property Act as an answer, is it material? Do they have the right to resort to the laws? Do you raise it by a cross complaint? Does the complaint itself, is it an indispensable element of a complaint for partition filed after 2023 in a tenancy in common relationship? That's, is that requirement? Does it say that? Generally the law is if it's not pleaded, it's waived. Nobody can resort to it. For example, you could even waive let's say that somebody brings something as vanilla as a breach of contract claim. They say we had a contract, it was breached in 2015. If the answer does not raise a defense of statute of limitations, the law is that it's waived, even for something as obvious as that, if it's not pleaded. And so do you have to raise it? In order to maintain that right? Or is it the judge's obligation to raise it sua sponte? Is the judge supposed to stop everybody and tell the lawyers you're doing it wrong and there's this other law and I'm going to apply that? It's not really questioned, it just says it applies. So something that maybe started out very clear is maybe not as clear as we would like. But let's move on. Let's see if anyone thinks this section is any clearer. Um, the next part about the applicability, it says in an action to partition real property, the property shall be partitioned under this chapter unless all the co-tenants otherwise agree in a record. And it says this chapter supplements the other provisions of this title, and if an action is governed by this chapter, the chapter shall control over any provisions of this title that are inconsistent. Well, let's ask. Does anybody think that number one is ambiguous? Can anyone find anything, I don't know, challenging or unclear about, let's just call it, sentence number one here? Anybody? Seen seen no objections. Everyone agrees it's clear. It's an action to partition real properties. Everyone knows what that is. Two brothers. One of them wants to partition, the other one doesn't. What's so hard about that? Where's the dispute? Well, let's go through it. If there's not a will or a trust, but just, let's say mother dies intestate and there's a probate proceeding to determine the ownership interest in the property, and she only has two sons. We'll make it simple. Is a proceeding in the estate administration under probate code section 11950 an action of partition? The probate code specifically uses the word partition. Is that a partition action? Let's make it a little bit different. It is a family law proceeding. Again, it's not two brothers, it's a husband and wife. Husband and wife get divorced. They own this house, and one of them wants partition. It's a family law proceeding dissolution under Family Code Section 2650. The Family Code uses the word partition. Does the Partition of Real Property Act apply in family law? Okay, let's get something totally outside the realm of brother, sister, husband, wife. Let's say two business partners. They have this idea for this company, and they're going to make widgets, and they're going to make them in downtown LA, and they buy a warehouse to for this widget factory. But then they have a breakup. Is a dissolution of a and they hold their warehouse in an LLC is a dissolution of a limited liability company under Corporations Code Section 17707.03 B1 an action of partition. The Corporations Code says that when an LLC is dissolved, the remedy for the assets is partition. That's what the law says. Is that a partition subject to the Partition of Real Property Act, even though it's not pleaded as a partition? The question is, what is an action to partition? Everyone thought it was so simple. Nobody here said, Eli, I don't know what you're talking about. We all thought it was so straightforward. Maybe not. How does this provision integrate with the remainder of the partition law that was left unchanged? Again, this is kind of why this background is helpful. Yeah, maybe, in Kentucky, they don't get into these issues in their family code and their corporations code and their probate code. California is a little different. We have much more extensive laws and not just statutory laws, but decisional laws. Nevertheless, both the probate code, the family code specifically use the word partition. The corporations code, the case law, uses the word partition. So, when does this act apply? It's kind of a nice question. Let's move on. Uh, so again, let's say you're able to resolve these very thorny issues of what is a partition and who gets a partition. Let's just say it's your two brothers, they inherit mom and dad's house, and one wants to buy or one wants to sell and the other doesn't. And a partition lawsuit gets filed. Okay. Now we're cooking. We're off to the races. It's all very simple. So let's look at it. There's an appraisal provision. Code of Civil Procedure Section 874.316. It says, except as provided, court shall determine the fair market value of the property by ordering an appraisal. If all tenants have agreed to the value of the property or another method of valuation, the court shall adopt that value or the value produced by the agreed method of valuation. Seems pretty straightforward. If the court determines that the evidentiary value of an appraisal is outweighed by the cost of the appraisal, the court, after an evidentiary hearing, shall determine the fair market value of the property and send notice to the parties of that value. If an appraisal is filed with the court pursuant to sub D, the court shall conduct a hearing to determine the fair market value of the property, not sooner than 30 days after a copy of the notice of the appraisal is sent to each party, whether or not objection to the appraisal is filed. In addition to the court-ordered appraisal, the court may consider any other evidence of value offered by a party. Okay, who thinks that's confusing? There's an appraisal. One wants to sell, the other one doesn't. He files for partition. It's an appraisal. How complicated could it be? I don't know. Let's see if I can do a good job of making a mess of it. Let's ask some questions. Anybody think this is unclear? See none. Let's go through it. What does it mean to say the evidentiary value of an appraisal is outweighed by the cost? And the court, after an evidentiary hearing, shall determine the market value of the property and send notice to the parties of the value. So is the cost of the appraisal, does that include attorney's time to appear at the hearing and the objection? What is the evidentiary value of an appraisal? Under the evidence code, an owner can testify as to value. Well, if an owner can testify as to value, then what is the evidentiary value of an appraisal? How do you measure the cost? The court time obviously is costly to the court. How many hearings are there going to be on this? How do you weigh that? Okay, that seems like it's messy, but okay, so there's an appraisal. Enough. Let's just go on. Who bears the cost of the appraisal? Statute doesn't say. So if you just want to sell, if one party wants to sell and the other one doesn't, they want the appraisal, do they have to pay for the full appraisal? What happens if they don't pay for the appraisal? What happens if they don't want it? What happens if they say, well, there's an appraisal, but I don't want it? Is the court still required to order it? And if they ask for an appraisal but they don't pay for it, does that prevent the partition from going forward? Is the party who doesn't want it the plaintiff? Are they required to bear the cost of the appraisal? What happens if they don't pay? What happens if the appraisal doesn't occur? What do you do then? Man, this statute, I thought it was so simple. It's maybe a little bit harder than we thought, but let's move on. Let's move on to another part of the procedure. So it says if an appraisal is filed, we went over F above, right? So here's the very next section, right? So it says after hearing on subdivision F, but before considering the merits of the partition action, the court shall determine the fair market value of the property and send notice to the parties of the value. Does anyone think that's tricky? Does anyone think they don't understand what that means? I don't see anybody piping up. Okay. What are the merits of a partition action? It states that the act applies when property is held in tenancy in common. What about if somebody disputes that the other person's an owner? What if they say, "Well, I'm on title with them, but they told me that I was the sole owner." How do you determine, I'm a constructive trustee. And okay, so how do you determine what to do with this appraisal if one asserts that the other's not an owner? If there's a buyout, but one asserts, well, the other person's a 0% owner, I'm 100%, so therefore the price that I pay them is nothing based on my assertion. Well, how does that make sense and that's what the court orders, that you pay them nothing based on this assertion? How do you determine the value of an appraisal and a buyout amount if you don't know the ownership interest of the parties? Well, let's actually say it's the other way. Let's say it's a clear case of fraud. There's a constructive trustee, there's an email that one says, "I agree that I won't be an owner and you're going to be the owner. You're going to be the sole owner. I'm going to be on title as a favor to you to help with the financing." Okay, very clear case of fraud. Does the court get to consider that? It says before considering the merits. Basically, this says even in a clear case of fraud, there's an email. No one disputes it. Does the court have to say, "Well, I can't consider that. That's the merits of the constructive fraud claim. So I'm going to order an appraisal and a buyout to occur. And if you don't do the buyout, then you're going to lose your buyout opportunity and the property is going to be sold, even in a clear case of fraud." It says before the merits. That's what the law says. But don't you need to decide who's an owner before you can determine the buyout, especially skipping ahead a little bit to the next section, 874.317? It says the buyout price is the appraisal multiplied by the ownership interest. But how do you know what the ownership interest even is? Especially if we're not considering the merits. Seems a little tricky. But let's move on. Let's say you can figure out these thorny questions of what is a partition action? Does the act apply? Who's an owner? Let's say it's very simple. Two brothers, 50-50, very clear, okay. Next section, the buyout provision. Okay. It says there's an appraisal done. Court determines a value. We're off to the races. It says 874.317 says that any other co-tenant, and this is paraphrased a little just because this section is a little wordy, but you'll have to trust me that I've fairly represented it here. And it says any other co-tenant has a right of first refusal and shall receive notice of that right. And within 45 days of receiving notice, the co-tenant may exercise that right of first refusal. The purchase price is the value of the entire parcel determined under section 874.316 multiplied by the co-tenant's fractional ownership interest of the entire parcel. Okay. Again, very simple. After expiration of the period, if one co-tenant makes the election, basically the actual election to purchase, then the ownership shares are reallocated. If multiple co-tenants, again, think about our two brothers and a sister, maybe one wants to sell, the others are fine maintaining ownership. Then if multiple co-tenants make an election, the ownership shares are reallocated. If no co-tenants make an election, then the partition action shall be resolved under section 874.318. The court sends notice. The court shall set a date within 60 days to pay the amounts in court. If no co-tenant pays, partition action shall be resolved under section 874.318. Okay. Does this seem straightforward, everybody? Now you're all probably gun shy by this stage. Um, but seems pretty straightforward. There's an appraisal, there's a buyout. If one wants to buy, the other has to sell. What couple people want to buy, and one has to sell. If nobody buys, all right, then it's resolved under this other section, 874.318. Okay, let's take a look. How does this section deal with a mortgage or a deed of trust on the property? So I've never really lived anywhere else. I've only kind of been a California kid, as you heard Howard share from my uh y y- you know uh introduction. Went to school, grew up here, went to school here. So I don't really know a lot about, real estate in Alabama. Honestly, I don't. I don't know a lot about real estate in Mississippi or South Carolina or, Kentucky for that matter. What I hear over and over again, what everyone tells me is owner real estate in California is so much more expensive than it is elsewhere. I think nobody would disagree with that. And so what comes along with that is this idea that you have to get a big mortgage to buy the real estate. Maybe you don't have to do that in Tennessee. Maybe you can pay cash. Or, even in our example of two brothers inheriting property, I have lots of clients who inherit property and there's still a mortgage on it. Maybe mom and dad died in their late 60s and there's still money left on the mortgage. Well, if the buyout price is the ownership shares multiplied by the appraisal, what do you do about the mortgage? How does that accounted for as part of this process, especially if we're not considering the merits? Again, we don't get to think about it. That's what it says. So let's imagine there's a house. It's in, let's call it Pasadena or La Jolla or I don't know, San Francisco. And it's inherited. And let's call it, this house in Pasadena. Let's say the house is worth $1 million, just to use a nice round figure. But there's still, $250,000 owed on the mortgage when mom and dad pass. Um, but the buyout price for the sister who wants to buy is the ownership shares times the appraisal. So the appraisal is $1 million. Brother, sister agreed. Sister's a 50% owner. So that would mean that her buyout price is $500,000. But so then brother gets $500,000, but there's no accounting for the mortgage. The house, the buyout price arguably should not be, 1 million times point 0.5 times half. It should be 750 times half. So the sister, under this law, could theoretically pay substantially more than she's supposed to. Just because there's a mortgage, just because people in North Carolina didn't think about how real estate is more expensive in California. For those of us who've been practicing, veterans of the partition law for a while, we all know claims for contribution. In other words, brother, two brothers inherit a house. One of them, maybe mom and dad didn't take care of it so well at the end. It needs a new roof. Brother number one pays for it. It needs new plumbing. Brother number one pays for it. It's still got a mortgage. Brother number one pays for it. Brother number one has spent, $100,000 on the house, even though as a 50% owner, he should spend 50,000. So in partition law, he has a claim for $50,000 in reimbursement from brother number two. And if the house is sold, he gets credit for that. But again, this doesn't really address that. It says appraisal times ownership interest, period. That's what it says. So did this eliminate the laws of contribution? What do you do about that? Procedurally, let's ask some easier questions. What happens if they miss the deadline? What happens if instead of 50 days after the appraisal is filed, they object or they say, I want to, I'll pay the money. They miss it. Let's say they miss it by a day. Do they still have that right? Is it a jurisdictional deadline? Is it subject to a 473 motion? Arguably, 473 says that the court can set aside any order. It doesn't say set aside any timeline. So if the court hears a 473 motion, is that setting aside the entire appraisal and you have to go back to zero? because somebody says they missed the deadline by a day. What are you supposed to do there? Is it a hard deadline or a soft deadline? Well, 874.317 doesn't tell us. So, there's some practical concerns here. Is that fair? Is that just? It's kind of interesting. Let's see if we can if we can get some clarity from the other sections. Okay. So let's say, nobody got tripped up from here to there. There's two brothers. They're both owners. It's a tenancy in common. They're 50%. There's an appraisal. Nobody makes the election to buy. Nobody disputes the appraisal. Brother number two says, I would love to have bought mom and dad's house in Pasadena. I just don't have the cash. I can't qualify for the mortgage. No one's disputing the mortgage amount. Let's say it's owned free and clear. Okay. It goes to a sale. We've done our appraisal process. We've done our buyout process. It says if it's not resolved, it goes to a sale. It says if the court orders a sale, the sale shall be an open market sale, unless an auction or sealed bids would be more economically advantageous. Honestly, I've never seen in almost 500 partitions, never seen an auction or sealed bids. Almost always open market sale. That's what everybody wants. That's what makes judges happy. If the court orders an open market sale not later than 10 days after the entry of the order, the court shall, quote, appoint a real estate broker and establish a commission for the sale. If the broker appointed under sub B obtains within a reasonable time an offer to purchase the property for at least the determination of value, the following requirements apply. One, the broker shall comply with the reporting requirements. The sale shall be completed in accordance with state law. And if the broker under sub B doesn't obtain an offer to purchase the property for at least the determination of value within a reasonable time, the court, after hearing, may do any of the following: approve the highest outstanding offer, redetermine the value of the property in order the property continue to be offered for an additional time, order the property be sold by sealed bids or at an auction. So, okay, seems pretty simple. No one does a buyout, 50% owners, you do a sale, right? Pretty simple. Well, and by the way, section 8, I'll just represent to you section 874.312.321 relates to notice provisions that are kind of similar to what happens in a probate sale. Basically just providing notice to all interested parties, making sure it's publicly noticed. Okay. For those of us who have been doing this a while, we all got used to attorney referees, right? You appoint some lawyer, they hire a realtor, and they kind of shepherd the process. If necessary, there's an eviction, they'll do an eviction, that sort of thing. Um, it's pretty simple. This section says you appoint a real estate broker. And while there are some attorneys who are brokers, generally the two are mutually exclusive. Real estate brokers, they're into real estate. Lawyers, funny enough, they're into law. And so what happens is, the court must appoint a broker, but then the broker must comply with the law. How does a real estate broker whose business is just buying and selling, let's say single family homes in Pasadena, how does he know what to file with the court? How does he know how to comply with the notice provisions in section 874.321? How practically is he going to do, you know, this sale while complying with the law on his own? Is that realistic? I don't know. I don't know. It's kind of an interesting question. Relatedly, if a party failed to make the election under earlier provisions, do they still have the right to make the election now? Well, it's going to open market sell. Why couldn't they be a buyer? Did they lose their shot? The earlier section says that that's their election. Is that waived? And again, all of this is assuming it's this waterfall. Okay, it's a partition of real property. It's a tenancy in common. There's an appraisal process. There's a buyout process. And it says, but if there's not a buyout, it's resolved as a sale. So wait a minute. Again, you could have a whole defense, a righteous defense to a partition, and the property's just going to get sold, and you can then do your trial on your defenses to the partition. That's what the law says, seemingly. It's kind of an interesting issue. When should you try those defenses? When should you try all those issues, the merits, as it were? It's a really good question. Once the property's sold, especially if somebody says, "Well, I have a life estate, I have a constructive trustee, I want to stay here for the rest of my life." Once that property's sold, I mean, the horse is kind of out of the barn. What do you do then? What kind of relief do you have for your client? You're going to unwind that sale? I don't know if that's realistic. That's some cold comfort. You're gonna file something. It's kind of interesting. So, some issues. Here's some related issues, and this kind of comes up from time to time. What happens if somebody dies in the middle of the partition? Technically, any cause of action the decedent possessed at death survives to their estate and may be maintained or continued by their personal representative. Where the decedent left the undivided interest in any property, a partition action may be brought by the personal representative against the other co-tenants or by the other co-tenants against the personal representative. But the probate code says. Again, there's that word partition in the probate code, right? Um, Under section 9823, the personal representative may commence partition action, may defend a partition action by their co-tenants without prior approval of the probate court. Technically, you don't need it. You just can request the Superior Court to sub in, according to the terms of the probate code. And again, the personal representative has explicit authority to commence and maintains actions and proceedings for the benefit of the state and defend actions proceedings brought against the decedent personal representative of the estate. So, I mean, how do you can sub somebody in? How does that work? Is a proper substitution, even if the probate court doesn't determine that they're a personal representative? Kind of interesting, right? How do you handle if you got two brothers? Turns out litigation is stressful. Some people don't handle it that well and they depart. How do you do that? What happens, in that situation? What happens if you can't find a personal representative or an heir? What happens to their interest? Do you have to do a whole probate and put the partition on hold in the interim? That's a whole thing, right? So, kind of a tricky issue. Um, that said, if you have a probate, you can partition. So this is kind of what we alluded to earlier. So there's three different types of partition in probate. Um, when the decedent's interest includes an undivided interest, the surviving co-owner's interests are obviously not part of the decedent's probate estate. So basically, let's say instead of two brothers, you have, well, actually, no. Let's say instead of mom and dad, you have two brothers, but they're grown. Each has their own family and they die. Well, can you partition it just between the two brothers? No. You need the one brother who died. Any partition action against his estate must be brought in Superior Court. Can't be done in the probate proceeding. There's some case law for you there. And there's part two. Well, but if it's just a mom and dad and they leave it to their heirs, and a proceeding in the estate administration may be commenced to partition each undivided interest before distribution. Again, there's that reference to partition that I alluded to earlier in the introduction. There's a case on that, interpreting, giving some treatment of that statute. So, there you go. Um, one of the options available in a probate proceeding is to partition by appraisal. That's kind of like our example that we just gave about the appraisal and the buyout and the sale. You can do that in probate, although it's voluntary. Um, so some estate planning tips, to take away for your clients, advise about the risks of partition. So again, it applies to tenancy in common, doesn't apply to joint tenancy. So if you were to leave your property to, two sons as joint tenants, the partition law wouldn't apply. The Partition of Real Property Act wouldn't apply, specifically. If there's multiple properties, maybe give one property to each party. If property is given to multiple heirs, make a careful choice about a tenant in common versus a joint tenant. If there's a single property, must be given to multiple heirs, consider structuring something in the trust about a buyout provision to avoid having them having to hire somebody like me, because nobody wants that. So, just some, for those of you in the estate planning world, some good tips. Otherwise, this is me and the team of lawyers working on this. We also have that whatever reason that slide didn't transfer. So, we have a blog. I think we've got hundreds of articles at this point about partition topics and related topics. So really good information for practitioners. And again, my office in LA is in Culver City. So at this point, I'd be happy to answer any questions that you may have. I see there's some in the Q&A, and I'll just kind of go through them. Looks like we've got about 10 or maybe 12, maybe 15 minutes left. So I'll go through them. And if anybody has any other questions, feel free to include them. So David Azar asks, can you consider including election by a non-moving party to get partition in kind instead of sale and to buy out the moving parties? Um, I'm not totally sure what you mean. What you can do is, if the property is susceptible to partition by division, you can seek that. So, for example, I have a number of clients in the Central Valley and they have not, a single family home in Pasadena. They've got ranch land or farmland, or, I've had some clients in Napa vineyard land. I have some clients with, commercial acreage, like in downtown Sacramento, and, they want to divide it. They want to keep some of it. There's, physical partition. So that's an issue. In that case, it's the Partition of Real Property Act, um, you know, generally says that there's a preference for physical division. So again, because this act originated in the American South, having to do with a lot of farmland that's inherited, there's a preference for physical division over partition by sale. So it's definitely something that arises, although it's, obviously less common in, very urban areas such as Los Angeles or San Francisco or San Diego. But so interesting. David, I'm not sure I totally answered your question. If I didn't, please add something to the Q&A and I'll try to do a better job. Um, but so moving on, Jeffrey Merriam Raywald asks, can you discuss application of the partition rules procedures to partnership dissolutions? Absolutely. We one of the things that we do, one of our firm's specialties versus some of the other firms that practice partition is, we're very versed in partnership disputes and partnership dissolutions, and so we have a number of those going right now involving partitioning the property as part of the partnership dissolution. Obviously there may be related claims, fiduciary duty, conversion, constructive fraud, things like that. You can also have a whole process where you'll have there's a statutory buyout under the RUPA, which is the Reformed or the Revised Uniform Partnership Act. The Uniform LLC law also has a related provision about a buyout. We've interacted with both of those. There's a statutory buyout provision relating to um, expert appraisals and how those are done. I think it's probably a little bit beyond the scope of this presentation. Needless to say, like there are parallel provisions and we've worked with them. But basically the idea is once it goes to a sale, especially if it's an LLC with a single entity asset, which is like such as a warehouse or real estate, the partition law, would apply. So, that's been kind of my experience with that. I mean, I could probably, talk another hour just about that issue. So I'll kind of, shortcut it here.
Well,
Um,
I sometimes act as like a provisional director, provisional partner. Is
yeah.
there any interplay between those roles where you would think you then wouldn't need a partition because you have a deciding vote in the entity?
Sorry, what's your question?
Well, is there what would be the interaction if instead of somebody says, I want to do partition, somebody says, no, let's just have a provisional director, provisional partner, and they will make the decision for the group, for the entity.
Sure, they could. I mean, I guess it's about the stage of the dissolution, right? So like if I think what you may be referring to is at an earlier stage upstream about should the entity be dissolved, can a buyout be done, under reasonable terms? Then the provisional director can help to make that decision in the instance of a deadlock. If, however, the court ultimately makes a decision that judicial dissolution is in the best interest of the party or the entity, then, one of the remedies is partition or just sale the assets so that the assets of the entity can be fairly divided between the parties instead of two people sharing, our warehouse. Two people share, $10 million or whatever it ends up being. But there are definitely some opportunities for a provisional director to foreclose a partition. It just depends, at what stage of the proceedings we're finding ourselves.
In the corporate setting, you have a Corporation Code 2000 election to avoid dissolution as well.
Sure, and there's all these issues about, well, what's the election? What's the valuation that's put on the cost of the election, right? And that determination. And sometimes people say, well, I don't agree with that determination, so I'm not going to make that election, or I can't afford it, right? And in which case, the alternative remedy, I think, only is partition. At least that's my kind of understanding. Yeah. Okay.
Thank you.
Uh, Cool. Good questions. Alice Graham asks, isn't there case law that partition applies to life estate? Actually, Alice, it's even better than that. There's a partition statute that says the partition applies to life estates. So yes, but yes, there is case law that partition applies to life estates. I've actually partitioned a life estate. Not only can you do it, I've done it. And there's a whole formula for determining the value of that life estate in that instance. Um, okay. Good question. David Azar asks, regarding your comment of the statutory ambiguity, that the valuation of partition comes before consideration of the merits of who is an owner. Has there simply been no reported appellate decisions yet since this act is new? And are you aware of any trial court decisions? So, David, I'm not aware of any treatment in California. I have reviewed the case law, the treatment in other states again, because one of the beauties of being a uniform act is you have the same law in Nevada or Ohio or Minnesota or whatever the case may be, and you can read appellate opinions from them, and we have a collection of them on our website. Kind of treating the act and kind of what it says, but nothing in California. No published opinion in California. I'm not aware of any trial court decisions on that topic. Frankly, those are a little harder to track down. But there's no appellate opinion on this specific question from any other state of which I'm aware. I haven't checked in maybe 18 months, so I could have missed something. But that's basically, my knowledge of that topic. Um, okay. So Alice asks, since partition is equitable, can a judge deny it if the judge thinks partition would be unfair to the defendant? So it's a nice question. So partition initially was an equitable proceeding. I guess it's still considered to be equitable. But there's actually I see this term thrown around a lot. Well, it's equitable, it's unfair, so we can stop it. There's actually a very specific meaning to the term equity, the distinction between law and equity. And basically, it has to do with whether there was a right to a jury trial at the time that California became a state at the institution of the state constitution in 1850. Because in 1850, the first act of the California legislature upon entering into statehood was to adopt the common law of England as existed in 1776, which basically in that time was based in large part on Blackstone's commentaries on the laws of England. So, and that was the definition of equity. Did you get a jury trial or not? In a nutshell. Since that time, however, the partition law, as we just discussed, has been codified. And so, yes, it is an equitable proceeding, but equity cannot necessarily override statute. And the partition law as it stands now, I think it's A72.720, says that partition is a matter of right unless barred by a valid waiver. So, basically, since that's and basically since 1976, since this partition law was codified and revised at that time, there's been no published decision that is allowed for the denial of a partition based on unfairness under the codified laws. Is a very long, winding answer to that question, but a very good one, Alice. So I don't think that fairness is a defense in that sense. Lark Gwartney asks, listing a property in the open market, knowing it has a first right of refusal, is against most MLS rules and can result in disciplinary action against the broker. True. Best practice, buyout value, feasibility, and execution or waiver should be resolved before listing with a broker on MLS. I can't fight with you, Lark. That's probably true. I think what's notable about this procedure is that it says that the sale for the broker happens only after the appraisal and the buyout. So under the law, I think it perfectly comports with what you're sharing. So I don't really see a conflict there. So I think we agree. But nice note. Um, Chantel Malmid asks, and I apologize if I'm butchering some of these names. I'm sorry about that. The statute is unclear as to how partition referees can or should be used to carry out the process of determining fair market value and conducting partition sales under the new regime. How would you interpret it? Well, I'd say that partition referees are not determining fair market value, right? The appraisal process is determining fair market value. That said, what I've seen is basically brokers listing these properties, set it whatever they think can sell, and whatever it gets, the court approves regardless of what the appraisal says. From a practical perspective, that's what I've seen. Um, Sally Williams asks, can court issue interlocutory order to destroy a joint tenancy so partition can proceed? Actually, a joint tenancy, an interlocutory judgment wouldn't sever the joint tenancy, it would just affirm it. So I don't, as Sally Williams. It's an interesting question. I have seen that argument. It is sever. So what I would say is it does sever the joint tenancy, but then that doesn't revert to apply the Partition of Real Property Act. It just says it's a joint tenancy, and so the Partition of Real Property Act doesn't apply. So that's the answer I have there. Oh, Sally Williams adds, without considering merits, where joint tenancy was obtained by fraud. Yeah, I haven't seen that. I would be a little surprised if the court used the statute in that way. Brian Lamb asks, does the California partition law apply to the division of common interest in a California residential mobile home? I would say that the Partition of Real Property Act applies to real property. And a mobile home, I think, is personalty, because it's registered with the Department of Motor Vehicles. So I don't believe it arguably doesn't fall within the Partition of Real Property Act. I've actually partitioned a couple mobile homes. I've never seen a court apply the Partition of Real Property Act to the mobile homes. I know that you have that on the real estate brokers test, they will inquire about mobile homes. But I think that's, the last time I looked at it, that's my memory of it. I could be wrong, but having partitioned a few mobile homes, I've never seen a court apply the act to those mobile homes. So that's a nice question. Um, William McPike asks, how do you perfect some recordable document like a deed or claim without litigation that what would be recorded? Not totally sure about your question, William. It's interesting. I feel like there's a piece I'm missing to really give you the best answer. Um, yeah, I feel like I'm missing a piece. I'm sorry. Matt Goodwin asks, joint tenants with right of survivorship assume if this is how it is held in the joint tenancy severs unilaterally and then seeks partition. Yeah, you can sever the joint tenancy and then seek partition. Nothing that prevents you from doing that. So, and then the Partition of Real Property Act would apply. So that's correct. Terry Cohn asks, what if part of the property is improved and part not? Who gets the part with the improvement? Is the divisional split by acreage, by value per square foot? It's a great question, Terry. Basically, it's a court determination as to whether partition by sale is more equitable than partition by division. In that case, one party would have to say, yeah, I get the house and they get the backyard, but that's fair. There is this concept of ulti, which basically means that if there's a physical division done, then an offsetting payment should happen between them to equalize the value between the parties. That said, I've never really it's theoretically possible. It's much harder in acreage cases involving farmland. In a case involving a single family home, I've never seen it. It's a very interesting issue. It's something that I think about a lot. I've seen some attorneys raise it. That said, I've never really seen a court embrace that perspective, just from my experience. But I'm not saying you're wrong. I'm just saying I haven't seen it with a lot of legs, if that's helpful. Um, okay, William McPike asks, how do you prove an easement boundary line where the barbed wire fence pit has been in place for 120 years and witnesses are dead? It's a great question. I'd probably start with a surveyor or an expert witness of some kind, especially if you're doing a physical partition. And the court can also, I've also had courts appoint referees to make that determination of a boundary line based on a written report. Um, so I think
It,
that would be the
this relates to a lecture I give on neighbor disputes, and he's talking about the theory of agreed boundaries. And the problem you have here is how do you show the agreement? So you're
yeah,
going to think of anything evidentiary you might be able to go back
yeah.
to evidence some agreement, maybe by the original people who put it in. You may look at subsequent owners and see if they conducted themselves in such a way that you can you can use that to evidence agreement. But the proof of agreement is probably crucial to that legal theory.
Well, and it sounds like you're all over it, Howard. But I do apologize. I do have to run to my next thing. It is 1:31. But thank you all for attending. And if anybody has any questions, feel free to reach out to our office and we'll help as best we can.
Thank you very much, Ellie. Really appreciate you putting on this program for us. And other than the fact that I think we are leaving with more questions than answers as to what's going on with
I
this
think that's
new
a
act.
compliment. I think that means it was well done.
Yeah, it means there's a lot of room for lawyering to go on, and I'm sure you guys are going to remain very busy. But thank you
Thank you.
for bringing your expertise to us today.
Thank you. All right. Bye.